Good afternoon, everyone. Welcome to the webinar today. My name is Aaron Williams, and I'm joined with my colleague, Iona Kaiser, from our Houston office. We are going to be talking to you all today about the intellectual property issues from 2020 that you guys need to know about. And I am going to pass it over to Iona to discuss patent prosecution issues from this past year. All of you should have access to a Q&A feature, and we will be taking questions throughout this webinar. So if you have any questions, feel free to leave them there, and we will try to address them as we go along. If we're not able to get to them during the presentation, we will be sure to follow up with you afterwards. So thank you very much.
All right. Hello, everyone. My name is Iona Kaiser. Like Aaron mentioned, I'm in the Houston office, so probably a little bit warmer than some of the rest of you out there. So let's go through some of the 2020 cases related to prosecution. The first one I want to talk to you about is Illumina versus Ariosa Diagnostics, because it's first, it's of course going to deal with the first section, section 101, and where it intersects with national phenomenon. An interesting background to this case is there was a prior case back in 1996 where Ariosa, the defendant in this case, was the plaintiff and asserted its patents suing Sequenom. In that case, it was a method for detecting paternally inherited cell-free fetal DNA in the plasma serum of the mother. That patent back in 1996 was found invalid under 101 because they said it was directed to a naturally occurring phenomenon that cell-free fetal DNA had always been present in the plasma serum of a mother. So with that case in mind, we move forward to this case. In this case, Ariosa itself was being sued by Illumina over two related patents. The patents in their background actually acknowledge that there was a natural occurrence of extracellular DNA in the maternal plasma. This case really seems to be drafted around what had happened to Ariosa. Illumina's patent identified the problem is separating the extracellular fetal DNA from the, quote, vast quantities of maternal DNA. So most of the plasma reflects the DNA of the mother. And they had a method for preparing an extracellular DNA fraction. They were looking to find a genetic locus of fetal chromosomal aberrations. The inventors in the background, in the specification said that they discovered that fetal DNA was generally found in small sections, so 500 base pairs or less, whereas maternal DNA was generally greater than 500 base pairs. So they did admit that there was a little bit of overlap, not that much different necessarily in size between fetal and maternal DNA. And the claim method, and this is, of course, pared down from the actual claim, but actually does show all of the elements. They were first going to extract DNA from the maternal plasma. They were then going to separate and remove a fraction of circulatory DNA under 500 pairs. And they were interested in finding DNA fractions that were under 500 pairs, but were still large enough to show a position where the gene was located, right, because they're trying to find an abnormality. And then they were going to analyze that fraction. Okay. That's the same thing. And this does give you the two patent numbers if you're interested in seeing the two patent numbers. So the court applied Mayo. Step one, are the claims directed to a natural phenomenon? And only if it's yes do you proceed to the next step. Step two, do the limitations of the claim, apart from the natural phenomenon, quote, transform the nature of the claim into a patent eligible? The majority notes that under Mayo, they have found all diagnostic methods unpatentable. So that's just something to be aware of. They stated that, even though it had nothing to do with this case, so it's dicta, but they stated it as if that was a bright line rule. But they said in this case, the claims were not a diagnostic or a method of treatment, but they were a method of preparation. So they're kind of setting up their transformation under step two of Mayo. For step one, they said that yes, this is a natural phenomenon. It is undisputed that they discovered a natural phenomenon. And they moved on to step two. Now, here's just a procedural issue. There's a co-defendant in this case, Roche, who was actually the party that made the summary judgment motion being appealed. It seems from reading the Federal Circuit's opinion in this case that this was a fairly early summary judgment motion, which is not all that unusual. And the court really took Roche to task for not committing to what exactly was the natural phenomenon. Quote, Roche's articulation of the natural phenomenon was a moving target throughout briefing and at oral argument. And they noted Roche's inability, despite its status as a moving party, to clearly identify the natural phenomenon. And then they adopted Illumina's articulation of a natural phenomenon, i.e. that cell-free fetal DNA tends to be shorter than cell-free maternal DNA in a mother's bloodstream. So the majority determined that the claimed process steps that lead to a DNA fraction that is different from the naturally occurring fraction in the mother's blood due to the enrichment, they're basically removing the larger DNA fractions. So the phenomenon that fetal DNA is shorter than maternal DNA, but to exploit that discovery in a method for preparation of a mixture of enriched fetal DNA. They actually discussed this in view of the prior Ariosa litigation, and this is a little bit long, so I'll try to just shorten it for you, but you have it in the presentation if you're interested. So they said in the earlier, Ariosa discovered that the cell-free DNA exists, and then they, quote, amplified it, again, by trying to extract non-maternal DNA, to a method to see that it exists. In contrast here, they said that in this case, the claimed maternal DNA is enriched have more fetal DNA. They seem to think that this was pretty dispositive to me. This is a little bit of splitting hairs. But this is how they distinguish why Ariosa lost in the previous litigation and should also lose in this summary judgment motion. There was a dissent, so the majority disregarded the well-established precedent for conducting ALICE, step 1 directed to, by failing to consider the patent's claimed advance. So in this case, the dissent would say that whether the steps are concrete is not the question, but where the written description identifies that technology is well-known or performed using commercially available tools or kits, it cannot logically constitute a claimed advance. What they're saying here is you discovered a natural phenomenon that the fetal DNA is a shorter length than the maternal DNA, and then you used already commercially available technology to separate the shorter DNA strands from the longer DNA strands. That was not a new portion of the patent. So the dissent would have found this to be not an advance in the art, and therefore would have invalidated the claims under 1. Okay, moving on. GS Cleantech v. Adkins. District Court found 4 patents for bio-oil recovery unenforceable for inequitable conduct during prosecution. This case, like all inequitable conduct cases, had some very interesting facts. In this case, the inventor had a pre-filing commercial offer for sale. That activity was not disclosed to the PTO, and the district court found that the inventors took affirmative steps to hide that fact from their lawyers, and then later tried to hide that fact from the USPTO when they discovered that that prior offer for sale might make them not be able to get a patent and therefore not profit. However, the holding was not limited to the inventors. The district court specifically found that Cantor Colburn acted inappropriately, either by purposeful evasion or failing to seek out relevant information such that they chose advocacy over candor. Not something you want to see written about you by a court. The court found the following facts. Cleantech knew that its offer for sale to AgroEnergy threatened its chances of patenting. Cleantech and its attorneys withheld evidence of a successful test in 2003 of the technology and made false representations by implying that the invention was not reduced to practice until 2004 after the filing date. Cleantech and its attorneys then threatened, it's not clear what the evidence was here, but threatened AgroEnergy to coerce its support regarding the critical date. So basically they tried to get AgroEnergy to lie about when the offer for sale was made to them. They also found a patently false statement in a declaration claiming that the July 23 proposal was delivered to AgroEnergy after the critical date. So they didn't just say this in regular filings, they actually submitted it in a declaration. And they found that failure to correct that declaration is strong evidence of intentional deceit. The practice here is one that nobody really needs to know, and it's that never, ever, ever make a false statement in a declaration, and if you find out one is false, correct it as soon as humanly possible. The Federal Circuit reviewed for an abuse of discretion and affirmed. Now, the abuse of discretion is where a lot of the commentary around this case is critiquing it. Inequitable conduct is generally reviewed for abuse of discretion, but this matter was resolved on summary judgment after an 8-day bench trial. Summary judgment is generally reviewed de novo. Nonetheless, the Federal Circuit refused to reconsider it in a full panel review. Cantor Colburn has filed a writ of certiorari to the U.S. Supreme Court. That was in November 2020, and we don't, as of today, know where that stands, but you can expect them to fight this as hard as they can. Okay, HCNP, which I'm going to call Horizon from now on, the Activist Labs. Horizon sued Activist for infringement over, that should be NSAID, for osteoarthritis knee pain. It was actually a cream that you rub on for pain. The Federal Circuit considered claims of indefiniteness, including whether consisting essentially of, a well-known transitional term, was indefinite in the context of the patent. So the claim at issue was this: a topical formulation consisting essentially of A, B, C, D, E, and the remainder water. Right? The district court found that the term consisting essentially of was indefinite. And they did note that the definition of consisting essentially of, the one that we're all familiar with, is that the term is construed to mean all the listed ingredients that follow the phrase and any unlisted ingredients that do not materially affect the basic and novel properties of the invention. That's what we're all used to seeing. So the parties disputed what the basic and novel properties were, and the district court found that you had to determine what those basic and novel properties are for claim construction, otherwise you don't know the metes and bounds of a consisting essentially of claim. The district court used the Nautilus standard to apply to the assessment of those basic and novel properties. In Nautilus, the Supreme Court held a patent is invalid for indefinite if its claims, read in light of the specification delineating the patent in prosecution history, fail to inform with reasonable certainty those skilled in the art about the scope of invention. I'm stressing claims here because that was an issue between the parties as this case went forward. The district court found 5 basic and novel properties. You can see them here. The one we're going to focus on is better drying time. The district court held that better drying time was indefinite because the specification included 2 different methods for evaluating that term, and they yielded different results. Verizon did not dispute that those 2 would give different results, but it first argued that the formulation cannot be indefinite because it lists specific ingredients. The Federal Circuit said that this would basically essentially render the essentially part of consisting essentially of out of the claim, that if you didn't have to consider non-listed ingredients, you essentially have a consisting of claim. It said the phrase signals that the invention necessarily includes the listed ingredients, but must be open to other ingredients that do not affect the basic and novel properties. The Federal Circuit accepted the district court's finding of those 5 basic and novel characteristics. Of note, the specification actually had a section called characteristics of the gel formulation that actually listed off these 5 basic and novel properties. And they further held that Nautilus was the correct standard. Now, the argument here was a little bit interesting. Horizon argued that Nautilus goes only to the claim, because the holding in Nautilus said it's claims read in light of the specification. It's an interesting argument. I think they're reading out the read in light of the specification. They essentially were saying you can't go back and do this against my transition phrase. It only goes to the claim elements. The Federal Circuit followed the district court's finding that activist is expert, that a person of ordinary skill in the art would not know under what standard to evaluate the drying time, because there were those 2 different ways to measure drying time. Horizon noted that the 2 different methods were clearly delineated in the patent, that one was an in vitro method and one was an in vivo method, and that anyone of skill in the art would understand that you're going to get different drying times if you're drying on a lab in the bench versus on someone's actual knee. And so they argued that the specification, activists argued that might be true, but throughout the patent specification, they used the terms drying rate and drying time interchangeably, and therefore blurred that line so that someone could understand the scope of the claim. The Federal Circuit held that an evaluation of the specification revealed inconsistencies of the property of better drying time, and they upheld the district court's finding. Okay, Eagle Pharma v. Slayback Pharma. This was ANDA litigation over a bendamustine formulation, and Eagle was asserting 4 patents. Slayback conceded that its genetic formulation literally infringed all the elements of the claims with one exception. Not, of course, unusual in ANDA litigation where you're trying to make a generic form of a drug, and therefore clearly you're going to have many of the same elements. So there were 4 patents. There were many patent claims, but both parties agreed that Claim 1 of the 796 patent was representative. So here's Claim 1. A non-aqueous liquid composition comprising the bendamustine or a pharmaceutically acceptable salt, and then a pharmaceutically acceptable fluid comprising a mixture of polyethylene and propylene glycol with a certain ratio, stabilizing amount of an antioxidant, and then the composition has certain impurities over a certain storage measured by a liquid chromatography. The underlying term there, pharmaceutically acceptable fluid, was where the parties were disagreeing on whether or not that was present. And then antioxidant will come up a little bit later in our discussion of this case. So Eagle asserted that the pharmaceutically acceptable fluid was not directly infringed, but was infringed under the doctrine of equivalence. Slayback moved for summary judgment, saying that there is a disclosure dedication doctrine was barring the DOE infringement. They said the asserted patents disclose but do not claim the alleged equivalent. In this case, Slayback's formulation used ethanol in place of propylene glycol. The Eagles patents did repeatedly describe ethanol as a potential choice for a pharmaceutically acceptable fluid. They quoted, in other aspects of the invention, the bendamustine-containing compositions include a pharmaceutically acceptable fluid, which contains one or more of propylene glycol, ethanol polyethylene glycol, benzoyl alcohol, and glucophorol, or in a stabilizing amount of chloride salt. And then they also said other fluids include PG, PEG, or ethanol in this embodiment of the invention. The Federal Circuit reviewed de novo and held that the disclosure doctrine bars an application of the DOE when it states that when a patent drafter discloses but declines the claimed subject matter, this action dedicates the unclaimed subject matter to the public. Eagle contended that the disclosure was for a different embodiment. So they said that their patent very clearly set out three categories of formulation: chloride salt formulations, antioxidant formulations, which is the claim at issue here, and DMSO formulations. And they said because the patents did not disclose ethanol as an alternative for PG for embodiment, including the antioxidant formulation, the doctrine should not apply. That basically, by pulling in ethanol, you had to mix different embodiments within the patent. The Federal Circuit looked to the Johnson decision about the disclosure dedication doctrine and said that that doctrine does not require the specification to disclose the allegedly dedicated subject matter in an embodiment that exactly matches the claimed embodiment. They said they rejected the embodiment level approach and denied the patentee's attempt to avoid dedication. So the Federal Circuit upheld the District Court's judgment of non-infringement on the pleading. Okay, Apple v. Fintiv. This is an IPR case, and this is a precedential case where the PTAB established factors, or I should say some factors, it will consider when deciding whether to deny a petition challenging a patent because an upcoming district court infringement trial will resolve the same questions. So as we're probably all aware, AA requires petitioners to file an IPR petition within 1 year after the date on which the petitioner is served with a complaint alleging infringement of the patent. However, since 2018, anybody who practices an IPR will know USPTO has regularly denied institution even within this time period, particularly as you get farther into the time period. In this case, Fintiv asked PTAB to use discretion to deny institution of an IPR due to the advanced state of parallel district court litigation over similar issues. So this is the precedential test that the board decided on. It's a non-exclusive six-factor test. First is the likelihood of a district court stay. Second, whether the trial is projected to occur before the deadline for the PTAB's written decision. Third, the court and the parties' investment in the district court proceedings. Here they're going to look at things like how far are you done with discovery, both paper discovery and depositions, basically how much money has gone into this case at the time. Overlap of the issues, so are the same claims and are at issue, and overlap with the parties, and then the catch-all, other circumstances that impact the board's exercise of discretion, including the merits. So these five factors are ones they're definitely going to look at, but then if you have a specific case where you think another factor is important, you can certainly bring it to the board's attention. In this case, the trial was actually scheduled for 2 months before the IPR decision would be due. Claim constructions and validity contentions were already complete, and the same claims and prior art were at issue, and the same parties were at issue. In view of all those facts, the USPTO denied the petition to implement an IPR. The holding suggests that it might be difficult to obtain IPR review in the rocket docket courts. Practice tip here is if you think you're going to want to, if you're the defendant, you think you want an IPR, do it as early as you can to try to get well before the district court's decision. That will not only help you get instituted before the board, it will also be more likely that the district court will enter you a stay. Of course, as we know from prior cases, this decision is not subject to appeal. There is no jurisdiction to hear appeals on a decision on whether or not to start an IPR. Okay, in re Google. This is a patent infringement suit filed in the Eastern District of Texas by Super Interconnect Tex SIT. Google petitioned for a writ of mandamus from the CFC to dismiss or transfer the dispute for lack of venue. Venue was based on the fact that Google had servers located in the Eastern District of Texas. Here's our patent venue statute, which we all know is being more closely looked at these days. Particularly, you have to have, a defendant has to have a residence, have committed acts of infringement, and has a regular and established place of business. It argued that venue is proper because Google had committed infringing acts in the district and has a regular and established place of business in the district due to the server locations. The Google business was provision of video and advertising service to the Eastern District of Texas through the internet. It was noted that no Google employees had ever visited the servers in the Eastern District, and they were just leasing the servers in the district. The district court found that the servers, which were owned and controlled by a third party, were enough to constitute a regular and established place of business. The AFC accepted the writ. This is a little bit interesting because Google had filed similar writ earlier to the CFC based on servers being located in the Eastern District of Texas, which was not accepted. So if at first you don't succeed, try again. And the CFC accepted the writ, and they considered the Cray factors. First, is there a physical place in the district, and that place must be a real property or leasehold interest? And second, is there a regular and established place of business? And they noted it must be a place where an employee or agent is conducting the defendant's business. So looking at those two factors, the Federal Circuit found that the leased shelf space or rack space can serve as a place, and here the GGC servers were in a fixed location within the Eastern District. And then they looked at whether that was a regular and established place of business for Google. And they concluded that the physical presence of an employee or agent was required in this particular case, but stopped short of making that a strict requirement. So in this case, venue failed, and they asked, Google was able to get the case transferred out to the Eastern District. I don't see any questions, so I think I will now pass it over to Aaron.
Thanks, Ayana. The Google case is going to create some very unique opportunities, I think, for patent litigation moving forward, particularly in various aspects involving e-commerce and things like that, where you can point to a specific location where goods are stored throughout the United States. So it opens up some new and unique avenues for pursuing defendants, but also unique and challenges for companies who are trying to protect where and how they get sued in federal court. So we'll be looking forward to see how that transpires. I know Google had recently filed another writ to the Eastern District, to the Federal Circuit, and the Federal Circuit denied it and said to come back after trial, and they might take up the issue again. So we might have some further clarity on that here either this year or next. With that, I'm going to transition into some of the Supreme Court cases from last year that touched on patent, trademark, and copyright issues. So the first decision, piggybacking off of the IPR issues that Iona talked about, is the Thrive v. Click-to-Call case. This was one of the bigger ones from this past year, and the case involved Click-to-Call, their 836 patent, which was related to technology for making anonymous phone calls. Click-to-Call had actually previously filed patent litigation on the 836 patent against Thrive back in 2001. but dismissed that litigation without prejudice to refile. Fast forward to 2013, and Thrive seeks to institute an IPR review against the 836 patent. So as you can tell, 12 years in between Thrive's first run-in with the 836 patent and when it finally approaches the USPTO to institute IPR. Click to Call argued that 35 USC Section 315B's one-year time bar precluded the bar from instituting the IPR. The board disagreed and instituted the IPR and validated 13 of the 836 patent's claims, and Click to Call appealed that decision to the Federal Circuit. So as Iona previewed as she was talking, the issue in this case was whether the Patent Trial and Appeal Board's decision to institute inter-parties review was appealable. And as you can imagine, the two sections at issue in this case were 35 USC Section 314D, the determination by the director whether to institute an inter-parties review under this section shall be final and non-appealable, as well as 35 USC Section 315B, which states in relevant part, an inter-parties review may not be instituted if the petition requesting the proceeding is filed more than 1 year after the date on which the petitioner, real party in interest, or privy of the petitioner is served with a complaint alleging infringement of the patent. So Thrive had previously been served with a complaint alleging infringement of the 836 patent, which was the subject of the IPR petition. The PTAB instituted, Click to Call ultimately appealed that decision to the Federal Circuit. The case went up to the Supreme Court. The Supreme Court, in the interim between the Federal Circuit's decision and the first writ of certiorari, had decided the case of Kuzo Speed Technologies LLC versus Lee. And so which in that case held in part that a board's determination to institute an IPR is not appealable if the challenge consists of questions closely tied to the application and interpretation of statutes related to that determination. So in light of its 2016 ruling, it sent Click to Call back to the Federal Circuit to make a determination in light of Kuzo. Well, while the case had gone up from the Federal Circuit to the Supreme Court, and following Kuzo, the Federal Circuit had previously ruled that in Wi-Fi 1 LLC versus Broadcom, that the application of 315B's time bar is not closely tied to the application and interpretation of statutes related to a determination of whether to institute an IPR, and is therefore an appealable decision. So having the Federal Circuit having the Click to Call case in front of it, as well as the Kuzo Speed Trial Technologies ruling and its Wi-Fi 1 decision, ruled en banc that it was an error for the board to have instituted the IPR against the 836 patent because the 2001 complaint started in 315B's one-year time bar. The case got appealed back to the Supreme Court, and the Supreme Court held that 315B's one-year time bar and decisions regarding it are closely tied to the application and interpretation of statutes related to that determination. And so it ruled that the Federal Circuit's decision to hear the appeal of the institution of the IPR decision was error. The court, in coming to this conclusion, I should say the majority opinion, focused on two pieces of policy that largely guided its decision. First, it stated that the IPR process created by the American Invents Act was concerned with over-patenting and its diminishment of competition, and that it was designed to weed out bad patent claims. And in light of this policy concern, the court was concerned that appeals related to 315B, i.e. the time bar, would operate to save bad patent claims, which would frustrate the purpose of the American Invents Act and its IPR proceedings. So what does this mean moving forward for litigation? Outside of merits appeals, the questions will be largely whether or not a particular issue is closely tied to a decision to institute inter partes review. In light of the Supreme Court's policy aims, it's likely that if a particular statute furthers the aims of the AIA and would otherwise operate to save a bad patent claim, a court is going to be more likely to find that it's closely tied to its issue of whether to institute the IPR. Since the click-to-call case, there's been a few cases decided that have expanded issues that are closely tied to the institution decision. An ESIP Series 2 LLC, the Federal Circuit ruled that the decision in click-to-call extends to the board's real party and interest determinations that require all interested parties to be named in a petition. Recently in November, the Federal Circuit ruled on a case that stated that click-to-call applies to PTAB determinations on whether a patent qualifies for covered business method review. So it appears moving forward right now that the default rule is that determinations will be considered closely tied moving forward. So shifting over to trademarks is the case of Roadmag Fasteners versus Fossil. This case, by way of some background, Roadmag is a manufacturer of magnetic fasteners, in part for fashion accessories such as handbags. Roadmag and Fossil had a business relationship under which Roadmag would provide Fossil with its magnetic snaps and clasps for Fossil's handbags, as well as other fashion accessories. Roadmag discovered that Fossil's Chinese factories were using counterfeit Roadmag fasteners, and Roadmag sued Fossil for trademark infringement under 15 U.S.C. 1125A. In the district court litigation, Roadmag succeeded in establishing infringement, but the district court denied an award of profits because the jury did not find that Fossil had acted willfully in its infringement. So the issue in this case, as some of you may be familiar, is whether a plaintiff must establish a defendant's willful infringement of a protected mark to recover a defendant's profits from sales of infringing goods under the Lanham Act. Depending on where some of you may practice or your businesses may be located, may have a gut reaction to answer this question differently. And that's largely because there was a very large circuit split over what was required to recover profits. At least 6 circuit courts required a showing of willful infringement before allowing disgorgement of profits. The two sections of the Lanham Act at issue in this case were 1125A, which is the infringement and false advertising provisions of the Lanham Act. And then the second section was 15 U.S.C. 1117A, which is the damages provision under the Lanham Act. And it provides in relevant part when a violation of any right of the registrant of a mark registered in the Patent and Trademark Office, a violation under 1125A or D of this title, or a willful violation under Section 1125C of this title, shall have been established in any civil action arising under this chapter, the plaintiff shall be entitled, subject to the principles of equity, to recover 1, the defendant's profits, 2, any damages sustained by the plaintiff, and 3, the costs of the action. So having that in front, there is no written requirement under the statute that for actions under 1125A, that a willful violation be proven in order to recover a defendant's profits, which is compared with 1125C. So the Supreme Court, looking at this issue, took a very textual approach to the question and found that there was no literal requirement for willfulness to recover profits under 1125A. But there was a literal requirement for willfulness for trademark dilution under 1125C. And 1125C was added by Congress after 1125A. While willfulness is no longer a mandatory requirement to recover profits, it's still an important factor. It's an important factor because 1117A also provides that if the court shall find that the amount of the recovery based on profits is either inadequate or excessive, the court may, in its discretion, enter judgment for such sum as the court shall find to be just, according to the circumstances of the case. As you may recall a little bit further up, 1117A also provides that the plaintiff's entitlement to a defendant's profits is also subject to the principles of equity. And so willfulness, under the court's approach, is still very much a factor and an important factor. It provides grounds for the court to feel as though it's not awarding a windfall to a plaintiff for innocent, quote-unquote, innocent conduct. However, the removal of it as a requirement will aid plaintiffs in trademark infringement actions, primarily because actual damages are often very difficult to prove. Profits, on the other hand, for a plaintiff, the plaintiff's only burden is to show sales revenue. And so those numbers are much easier and less expensive to prove at trial. And so it will give plaintiffs an opportunity as well as an incentive to continue with what can be lengthy and expensive litigation. The next case we're going to talk about is the USPTO versus Booking.com, which involves branding around generic and composite terms involving generic terms. So by way of background, the travel registration website, Booking.com, which most of you are probably familiar with, attempted to register Booking.com as a word mark with the USPTO. The USPTO denied the application because it said it was a generic name for an online hotel reservation service. Booking.com appealed that, and that denial was affirmed by the Trademark Trial and Appeal Board. And so Booking.com filed suit in the district court. While in front of the district court, it presented survey evidence that showed that 74.8% of consumers associated Booking.com with a brand rather than a generic service. The district court ruled that although booking was a generic term for a service, Booking.com as a whole was nevertheless a descriptive mark, and that Booking.com had met its burden of demonstrating that the proposed mark had acquired secondary meaning. The USPTO appealed that ruling to the Fourth Circuit, which affirmed the district court's ruling and declined to adopt the USPTO's position that a generic term plus .com was necessarily per se generic. And so the issue before the Supreme Court was whether the addition of .com at the end of a generic term was eligible for trademark protection. The Supreme Court, like the Fourth Circuit, rejected the USPTO's per se rule. As you may be aware, trademark eligibility often turns on the mark's capacity to uniquely distinguish goods and services in commerce. It's what we think of when we look at images or words and the good that it conjures in our head. The distinctiveness is often described on a scale moving from generic as the least generic to fanciful, which is the easiest to protect. Generic names are ineligible for protection because the name of the good itself, i.e., wine, shoes, things like that, are incapable of distinguishing one producer's goods from the goods of another. The majority at the Supreme Court provided kind of some guideposts that both of the parties agreed on, which was first, that a generic term names a class of goods or services rather than any particular feature or exemplification of the class. Second, that distinctiveness of a compound term hinges on the term's meaning as a whole, not its parts in isolation. And third, that meaning of a term is from the perspective of the consumer. Thus, whether Booking.com is generic turns on whether the term taken as a whole signifies to consumers the class of online hotel reservation services. So the Supreme Court provided a few examples of what genericness might look like with respect to Booking.com. If Booking.com was actually generic, consumers would understand Booking.com to be generic for other booking services such as Travelocity. Also, a customer seeking booking services would ask a frequent traveler for her favorite Booking.com provider. And so the court went on to hold that there's no per se rule, and whether the mark is generic and therefore not eligible for trademark protection requires consideration of evidence regarding the established meaning to consumers. So what this case does moving forward is, although it's not impossible to brand yourself around a generic term, the burden of doing so is very high. Booking.com was able to provide survey evidence around its brand that consumers recognized it as a standalone entity rather than a class of goods or services. Such survey evidence is often very expensive to manufacture and put together and prepare, and is often not available for new and startup entities. And so if you are thinking about branding yourself around a generic term, realize that it will take oftentimes take a number of years to build a brand reputation for your business in order to get to the level of survey evidence that is most likely necessary to show that your brand name has moved from a generic identifier to a distinctive or descriptive mark. The next case will shift over to copyright and state sovereign immunity. So this case, interestingly enough, involves sunken treasure in short order. The case originated from North Carolina's 1996 expedition to recover the infamous pirate Blackbeard's sunken ship in the state's territorial waters. Frederick Allen was hired as a contractor to film and photographically document the expedition, which lasted more than a decade. Allen, while he was performing this work, registered copyrights on all of his videos and photos taken during the process. North Carolina published a number of his works, and he objected, and the parties ultimately reached a settlement on the matter. So, end of story. Not really. Despite Allen's objection and the party settlement, North Carolina went on to use 5 more of Allen's videos on its website and published at least one of his photos in a newsletter that it circulated. Allen sued the state for copyright infringement under the 1990 Copyright Remedy Clarification Act, which provided that no state shall be immune under the 11th Amendment or any other doctrine of sovereign immunity from suit in federal court for copyright infringement. So naturally, North Carolina's defense was, we have sovereign immunity. And the case went up through the district courts, up to the Supreme Court, and the issue in front of the Supreme Court was whether or not a copyright owner was permitted to sue a state for copyright infringement in federal court. Now, along with the Copyright Remedy Clarification Act, Congress had also previously passed the Patent Remedy Act, which contained a similar provision stating that no state shall be immune under the 11th Amendment or any other doctrine of sovereign immunity from suit in federal court for patent infringement. That act had previously been litigated in a case known as Florida Prepaid, which addressed the Patent Act and found that the Congress's attempt to abrogate state sovereign immunity was outside of its authority. In particular, for Congress's action to fall within its authority, there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end, which in kind of plain terms requires that there must be a clear intent by Congress to abrogate sovereign immunity, and two, evidence of widespread and persisting deprivation of rights. As the court had previously ruled in Florida Prepaid, and it did in this case, Congress had failed to provide evidence of widespread and persisting deprivation of rights, copyright rights by states. And so the Supreme Court held that the provision abrogating sovereign immunity under the Copyright Remedy Clarification Act was unconstitutional, and Allen was prohibited from suing North Carolina in federal court. So moving forward, as it stands right now, copyright holders are unable to sue states for copyright infringement. At least in federal courts, there may be certain state remedies available depending on the location and the state involved. Until new legislation is created that's tailored to the precedents in Florida Prepaid and Allen v. Cooper, it seems likely that states will continue to be able to act with relative immunity for their actions. Senators Tom Tillis, a Republican of North Carolina, and Patrick Leahy, a Democrat from Vermont, sent a letter to the Copyright Office in light of Allen, noting that the case created a situation in which copyright owners are without remedy if a state infringes their copyright and claims state immunity. Congress appears to be taking measures to improve the evidentiary record that the Supreme Court chastised them for. There's been a call for comments that was released in November and closed in December of 2020, but the results of that study have not yet been released. So there may be future legislation to address the issues in the coming years. Okay. The big case of 2020 that actually never was due to COVID, which was a theme for most of us this year, I assume, is the case of Google v. Oracle and Google's use of Oracle's Java source code. This litigation has been ongoing now for over a decade. Oracle first sued Google in 2010 for allegedly copying more than 11,000 lines of code from Oracle's proprietary APIs, which are application programming interfaces. They're pre-written chunks of Java code that make it easier to write more common functions. Java, as some of you may know, is an open source software and free for anyone to use, but Oracle sells access to its proprietary APIs. When designing the software platform for its Android phones, Google created its own library of APIs, but it copied portions of Oracle's code as well as the overall structure, sequence, and organization of its API library. This case was argued to the Supreme Court in the late fall of 2020 and is currently awaiting a decision. There are two issues before the court. The first is whether is computer software code functional and therefore not a protectable form of creative expression under copyright law. This was Google's first argument, and in 2012, the district court agreed with Google that the code it copied was functional and therefore not subject to copyright protection because it was not a protectable form of creative expression. The Federal Circuit reversed and remanded the case to the district court, indicating that although the code language might have been functional, that should not automatically preclude the code from copyright protection. The Federal Circuit stated an original work, even one that serves a function, is entitled to copyright protection as long as the author had multiple ways to express the underlying idea. Google could have structured Android differently and could have chosen different ways to express and implement the functionality that it copied. So back before the district court, Google raised a second argument, which was whether or not under the fair use doctrine, it was permitted to use, without Oracle's permission, portions of Oracle's software code in its Android platform. In 2016, like in 2012, the district court agreed with Google that it had made a fair use of Oracle's code. But like before, the Federal Circuit overturned the district court's decision, stating that there was nothing fair about what Google did. The Federal Circuit stated, although Google could have furthered copyright's goals of promoting creative expression and innovation by developing its own code or by licensing Oracle's code for use in developing a new platform, it chose to copy Oracle's creative efforts instead. Google thereafter has appealed the Federal Circuit's ruling to the Supreme Court, and both of these issues are ripe for a decision coming soon. How the court rules, just how transformative this ruling is yet to be seen. It's one of the, it will be the first decision by the Supreme Court involving copyright and software code, and so it has the capabilities of potentially revolutionizing the industry and how the industry does business. It also will be one of the first times that the court has weighed in on the fair use doctrine in a number of years. During oral arguments this past year, the justices seemed skeptical of both sides. Chief Justice Roberts, in response to Google's argument that developers must be able to copy and reuse code if there's no other way to write it, said to counsel, you say that was the only way for you to do it, but you know, cracking the safe may be the only way to get the money that you want, but that doesn't mean you can do it. Justice Breyer, on the other hand, in response to concerns raised over Oracle's seeming monopoly over this code language, likened it to a keyboard, saying you didn't need to have a QWERTY keyboard at the beginning. But my God, if you let someone have a copyright on that now, they would control all typewriters and keyboards. So the court, at least right now, is skeptically split on these issues. And so it will be interesting to see both what the majority does with the case and just how large of a majority there is on some of these issues. We have about 5 minutes left for questions. I don't see any at the moment. So I will take this opportunity real quickly. In about 2 weeks' time, myself and my colleague, Bill Oldek, will be doing a presentation on intellectual property law cases that are going to be decided here in 2021 and preview some of the issues that you should be focusing on and considering as you move forward in this year and in years to come with your businesses. Registration details for that webinar can be found on our website as well as LinkedIn. And hope that if you enjoyed this presentation, you will join us for that. And with that, I hope that you all have a great rest of your day, and we will talk soon. So thank you very much.
Yes, thank you.